In employment litigation, defendants, the former employers, often engage in very broad ranging investigations against the plaintiff. To put it simply, they dig deep, especially in wrongful termination cases. There's every incentive to dig up every skeleton in that former employee's closet, anything that can bear on their fitness as an employee. So, wrongful termination litigation, it isn't for the faint of heart. There's a legal doctrine that actually incentivizes employers, at least in California, to go digging up additional reasons to fire an employee. Now, not only to justify or shore up evidence of their original reason for firing an employee, but to find just brand new reasons. If they suspect any kind of misconduct, but they hadn't come up with any evidence, hadn't really investigated before, there's no time like litigation discovery to do so. The doctrine in California called the after acquired evidence doctrine, that gives employers the reason to go after what's called after acquired evidence, something that would be sufficient to justify immediate termination. That would be the mother lode if they discovered some kind of misconduct, let's say embezzlement of company funds or defrauding your company's customers. Just black and white evidence of misconduct that would allow a company to fire a worker anyway. So why is that allowed? Why is that kind of evidence allowed? Well, the evidence does not absolve a company for wrongful termination if the termination was originally unlawful, if it was based on unlawful reasons originally. But what it does is the new evidence of another reason to fire this person would absolve the company of damages from that point in time forward. So in other words, the worker who embezzled, from the time that that embezzlement is discovered, that worker can't recover any more damages for their earlier wrongful termination. So if they're able to prove that the termination was originally wrongful, they can recover damages up to that point in time when the embezzlement was discovered. Now, that is the after acquired evidence in a nutshell. It's a little bit oversimplified in this clip, and please remember, this does not constitute legal advice. Every employment case is different and has to be assessed individually. So if you'd like individual advice or a consultation, feel free to contact me. Contact information will follow. Thank you.